Hello everyone, I'm Steve Thomas. I'm a partner in the HER's commercial team. We have a team of 15 lawyers across all our offices advising on a range of B2B and B2C contract issues. So if you have any questions about your contract issues, please do get in touch. This session looks into the use of indemnities in commercial contracts and the law behind indemnities, some of the common misconceptions and key tips for you when you're drafting indemnities. Any lawyer drafting and negotiating business contracts will know that there's an increased tendency nowadays for businesses, in particular in my experience larger businesses, to litter their contracts with indemnities and on occasion include blanket indemnities covering all breaches of the agreement. It appears that this practice has been strongly influenced by behaviour in the US. However, an indemnity is, if properly drafted, a very strong remedy which can create significant risks for the indemnifying party. As such, as commercial lawyers will know, that the negotiation of indemnities is often a very hotly contested negotiation point in the contract. So the purpose of today's session is to review the law around indemnities in the UK and provide some tips to inform your approach to drafting a negotiation. Okay, to start with, so what's the purpose of an indemnity? A draftsman drafting an indemnity for the benefit of his or her client typically has the following linked objectives in mind. Fundamentally, the objective is to allocate the risk associated with a specified event occurring between the parties to one party. So, say for example, the losses incurred as a consequence of a future change in VAT law. That's the fundamental objective. Generally, I think it's fair to say that also then the draftsman is intending to provide what's known as full recovery, i.e. the ability for the indemnified party to recover all losses suffered if that identified event occurs on a pound for pound basis without being subject to the legal hurdles of remoteness, causation or mitigation. This is what's sometimes known as a classic indemnity. But is that true? Well, it depends. It's interesting to note, in most cases, indemnities are triggered by some form of default on the part of the indemnifying party, but that's not always the case. So what does the law say on indemnities? The interesting point to make first off is there's no settled law on indemnities in the UK, excluding known statutory provisions such as UCTA and the consumer rights legislation. Indemnities are in effect a creature of contract. As a consequence, they are very flexible because you can draft into your contract whatever you want your indemnity to do, but there is, as a result of that, significant risk of challenge if you get the drafting wrong. So flowing on from that, normal contract interpretation principles apply to your indemnity. So just a quick reminder of those. I think the key contract interpretation principles that courts are focused on is loyalty to the text. Consider the text of the provision and give it appropriate weight. Along with that, courts will look at what's called the whole contract approach. They'll consider how the indemnity sits in the context of the remainder of the contract and all the other provisions. They'll look at context, consider the factual, legal and regulatory background to the contract, business common sense, and giving appropriate weight to business common sense or the commercial purpose of the contract or provision, and reasonableness. Courts are obviously keen to ensure that the words of the contract would not lead to totally unreasonable results. But fundamentally, it's important to remember that the starting point and usually the end point of questions of interpretation are the words themselves. So it's really important that the drafting is clear. The other key message looking at the case law is that the courts will look to analyse indemnities into two separate categories. Indemnities that create what's known as a debt claim and indemnities that create a damages claim. Let's look at those different types of claims. So debt claim, what are we talking about when we're talking about debt claim? Broadly speaking, if an indemnity falls into this category, a debt claim, the rules of remoteness and mitigation do not apply. You have your classic indemnity and the indemnified party will be entitled to full recovery on a pound for pound basis. So that is the objective. If you're drafting the indemnity for the indemnified party, that's what you're trying to achieve. So what is it? Essentially, a debt claim is a claim for a specified sum that is ascertainable under the terms of the contract when the payment is due. So, for example, in the share purchase agreement, the seller agrees to pay the buyer the amount of any pre-completion tax liability of the target. So the essence of this is that the court has a clear and liquidated amount that the contract provides is payable if the trigger event occurs, thus removing any ambiguity for the court to wrestle with. It's put simply, the court is not required to make any assessment as to loss because the loss is clear and liquidated, either in specifically in that contractual provision or there's a mechanism for calculating it. In that scenario, all the normal rules around contract damages will not apply and you will obtain full recovery. In practice, I'm sure most practitioners will be aware, most indemnities actually do not cover that type of situation, and often it is not possible to quantify the loss in any clear way at the point the contract's entered into. So let's look at the other type of category of claim that the courts will analyse indemnities within, damages claim. In essence, a damages claim is pretty much anything else, any indemnity which is not a debt claim, a situation where it's not possible to ascertain the loss that can be recovered at the point the contract is entered into. The case law in this area is much more muddled, but the bottom line is that courts are generally reticent to depart from the well-established approach to not awarding unforeseeable losses, not rewarding parties who haven't mitigated their loss, etc. So broadly speaking, courts are not prepared to tolerate unreasonable behaviour or effectively give parties a windfall. So in this scenario, to obtain your pound for pound recovery, the indemnified party would need to include express wording in the indemnity showing very clear evidence that this is the intention of the parties, in effect, to remove those normal contractual protections. And I'm afraid in the absence of such wording, the courts are likely to revert to the normal principles of remoteness, causation and mitigation when analysing indemnities. So I think hopefully you'll see from that is if you don't get your drafting right in a damages indemnity situation, then you're effectively in the same position as having a breach of contract claim because all the normal principles apply. So if you're drafting for an indemnified party, you need to be very careful. So let's have a look at some practical tips to help the different parties to the indemnity. So starting with the indemnified party, from an indemnified party's point of view, obviously the first point is if you can structure it, the indemnity as a debt claim, then that's the optimal option. Try and find some concept where you can either specify what the loss is or have some mechanism for calculating that loss that's specified in the indemnity. If you can do that, then you can ensure that the indemnity is treated as a debt claim and the normal rules of causation and mitigation will not apply. As I've said before, I appreciate that, and often in many cases that will not be particularly easy to do. If that's not possible, you need to incorporate very clear wording into your indemnity to ensure that you make it clear that the normal contractual principles won't apply. I put a passage from a case that the Court of Appeal made a judgment on, and what that is looking at is the causal words, in particular where it says the indemnity relates to claims as a result of or arising out of or in connection with the performance or non-performance of the contract. And in that situation, the Court of Appeal found that the connecting links, the words as a result of or arising out of or in connection with the contract, and in particular the words in connection with the contract, provided the widest possible causal link. So in connection with the contract, it's good language to keep the indemnity as broad as possible. Look to ensure that the remoteness principle does not apply. So we would typically advise if you add in words, say your indemnity applies to losses whether foreseeable or not, is a good way of making it clear that the parties are not intending the remoteness principle to apply. And similarly with the duty of mitigate, include some express provision to make it clear that duty to mitigate does not apply in respect of that indemnity. So I've listed some wording there. So neither party's recovery under an indemnity set out in this agreement shall be under a duty to mitigate the losses suffered. That type of language would be important. Now, I appreciate that in reality, drawing attention in the contract to these controversial issues will be a concern for the draftsman, because you're automatically creating a situation which is going to be a negotiation point. I think that's inevitable in these situations, and I think what I would say is that it's important as part of that negotiation that you as the indemnified party or the advisor of the indemnified party need to be able to justify that the indemnity reflects a reasonable allocation of risk in that situation, and that the situation deserves a full recovery indemnity as opposed to one that is qualified in some way. A couple of other tips. Obviously, it's really important as part of the drafting to ensure that the trigger event for the indemnity is very clearly drafted. And this is a personal bugbear of mine, but I would advise you not to rely on blanket indemnities of the nature of an indemnity for all losses arising from any breach of the contract. As I've said before, in reality, unless you have some further protections, in any event, I think those sorts of indemnities are likely to be treated or subject to normal contractual principles in any event. But I would encourage you to be more educated and clear about the types of indemnities that you need to recover in your contract negotiation processes. So tips for the indemnifying party. Obviously the first tip is to try and persuade the other side to remove the indemnity completely. And a number of questions I would typically ask are, is it appropriate for one side to in effect insure the other side for a particular risk? Is that reasonable? If the indemnity relates to a breach event, then of course the other party is entitled to their normal breach of contract remedy. So why is it necessary for them to have any specific additional rights over and above that? And importantly, to disapply the normal contractual principles that we've talked about. In my view, it should be in a pretty exceptional situation where in a breach type scenario, some error in the future, one party should have those exceptional rights. I mean, I think you would perfectly entitled to reject this is the market practice type arguments that you receive from some lawyers and some parties. In my view, in the vast majority of cases, that simply isn't the case. All of these types of indemnities are very fact specific, and both parties are entitled to negotiate on those. There are some, I guess, exceptions to that. If you're dealing with a bank, for example, it can be extremely difficult to persuade them not to have an indemnity for confidentiality breaches or data protection breaches. So there are a few limited scenarios, but as a general rule, I wouldn't accept this is market practice argument. If you can't persuade the other side to remove the indemnity completely, look to narrow it. One way of narrowing it is to limit it to third-party claims only, and that can be helpful to reduce the risk associated with the indemnity. I think it's really essential, tip 3, to ensure the indemnities are very expressly covered by the contract liability provisions in the contract, the cap on liability, and also the exclusion in relation to indirect losses and loss of profit, etc. I think that's a very important negotiation to have. Sometimes if you're acting for the indemnifying party, you won't win that argument in all cases, but in my experience, generally speaking, you should be successful in getting the liability capped in some way. I think it's really, I would strongly resist a situation where your liability is unlimited. Don't assume that parties will not move on that. In my experience, in the vast majority of cases, they will, and you will be able to get a cap, even if it is a greater cap than the cap you've agreed for other general liabilities under the contract. As we've said before, include an express provision on the duty to mitigate on the indemnified party, and also I advise there's some form of conduct of claims clause incorporated to protect yourself in terms of the indemnity. If possible, make the indemnity rights conditional on the other side complying with those conduct of claims principles. That can be a tricky negotiation, but if you can get it, I would certainly advise it. And then the other elements of that are ensuring you're notified of claims that might result in a claim under the indemnity, and ideally ensure that you have conduct of any litigation. Again, a difficult negotiation point, but as long as you've got some provision to ensure that you're involved and consulted with any key decisions associated with the indemnity claim, that's important to have. 3 final tips. If you're acting for the indemnified party, I would, generally speaking, recommend that you remove the words hold harmless. There has been some case law to imply that these words effectively mean that you can't bring some form of counterclaim against the beneficiary of the indemnity, and there's a potential that it means that you will be liable for losses as the indemnifying party which were actually caused by a breach or contributory negligence of the beneficiary, and those words prevent that. So if you're acting for the indemnifying party, I would certainly look to delete the words hold harmless. Tip number 7, avoid that very broad indemnities, which are indemnities which result from acts and omissions. As a general recommendation, if you're advising an indemnifying party, I would, if you have to give that type of indemnity, it should be in relation to a breach of contract, not just acts and omissions, because acts and omissions obviously could be some act which is not unlawful or breach of the contract in any way. And then finally, I think it is, if you are giving indemnities, really important to ensure you consult with your insurance broker or insurer to make sure that they're comfortable and the insurance policy will respond if a claim is made under that indemnity. The broad logic behind that is that in giving indemnities, particularly where some of the normal contractual principles of mitigation and remoteness are disapplied and not applying, is that you have a remedy in the hands of the indemnified party which is much greater effectively than in the normal legal situation. It should not be assumed that the insurer will simply pick up that difference if you or your client decides in a contract negotiation to concede on those rights. So it is really important to ensure that the indemnity wording is checked with your insurance broker. A few final observations. Indemnities are not a panacea, as we've discussed. I think if people are thinking, drafters are thinking that in every case you'll get a pound for pound recovery without mitigation, remoteness, causation applying, then you might be in for an unpleasant surprise. As we've discussed, drafting and careful drafting of these provisions remains essential to ensure that you get the protection and the position and the outcome that you expect. My final point is, I think in the course of that, it's important to be reasonable, to ensure that the indemnity draft reflects a reasonable allocation of risk between the parties, looking at the overall context and the ability of the indemnifying party to mitigate and be in control of whether or not that risk occurs. So that's the end of my session. Thank you very much for listening. Please do get in touch if you wish to discuss any of the issues I've raised. Thank you.